All right, good afternoon, everyone. I'm Rachel Hayes. I'm the Dean of the David Eccles School of Business, just a little bit up the road from here. And I just want to welcome everybody to today's event. Do consumers still reign supreme in the antitrust hierarchy? How antitrust can promote the interests of workers and other stakeholders in the economy. This event is sponsored by the Utah Project, which is a collaboration of economics faculty and law faculty interested in antitrust and consumer protection. We are honored to have two leading federal officials from the Department of Justice and the Federal Trade Commission here at the University of Utah to provide their insights about federal antitrust policy. From the perspective of the business school, we recognize that it's important for Utah's business community to understand how the antitrust rules are evolving and how those rules impact the ability of small businesses and entrepreneurs to thrive in our community. At this time, I'd like to turn the podium over to Professor Chris Peterson, the John J. Flynn Endowed Professor of Law at the S.J. Quinney College of Law, to introduce our speakers and panel. Thank you.
Well, hi, everyone. Thank you so much for coming. I am delighted to be hosting two, in particular, such distinguished guests who have flown in from Washington, D.C. to talk about some of the most important consumer protection and antitrust issues facing America today. Our first speaker will be Commissioner Alvaro Bedoya. Commissioner Bedoya was nominated by President Biden and confirmed by the Senate in 2022. Prior to this, he was a visiting law professor at Georgetown University, where he served as the founding director of the Center on Privacy and Technology. He's been influential in research and policy at the intersection of privacy and civil rights, including an influential 2016 report on the use of facial recognition by law enforcement and the risks that it poses to privacy, civil liberties, and civil rights. He also previously served as the first chief counsel to the Senate Judiciary Committee on Privacy, Technology, and the Law, and chief counsel to former Senator Al Franken of Minnesota. Prior to that, he was an associate at the law firm of Wilmer Hale. He's a naturalized immigrant born in Peru and raised in upstate New York. Commissioner Bedoya previously co-founded the Esperanza Education Fund, which provides college scholarships to immigrant students in the Washington, D.C., Virginia, Maryland area. And he also served as on the board of directors of the Hispanic Bar Association of the District of Columbia. So after Commissioner Bedoya shares some comments with us, we're then going to invite up Professor Hal Singer, who is an economics professor, for a fireside chat. There's no fireside, but you get the idea, with Jonathan Cantor. And Jonathan Cantor is the Assistant Attorney General for the Antitrust Division of the United States Department of Justice. Mr. Cantor is the senior official within the Department of Justice tasked with antitrust law enforcement, with shared civil and antitrust enforcement with the Federal Trade Commission, and also exclusive jurisdiction over federal criminal antitrust prosecutions. Mr. Cantor began his career as an attorney for the Federal Trade Commission's Bureau of Competition, and he then turned to private practice, eventually making partner at two prominent national law firms, first at Cadwalder, Wickersham, and Taft, and then later at Paul Weiss. When President Biden nominated Mr. Cantor in 2021 to be the Assistant Attorney General for the Antitrust Division, he was endorsed by 9 Assistant Attorneys General for the Antitrust Division, including his immediate predecessor in the office during the Trump administration. Throughout his career, Mr. Cantor has been a leading advocate for strong and meaningful antitrust enforcement and competition policy. Born in New York City, Mr. Cantor was raised in Queens by his parents, both of whom were elementary school teachers, which is maybe my favorite thing in his bio. So please join me in giving a warm welcome to both of them, and especially to Mr. Bedoya, or Commissioner Bedoya, who'll be starting us off. Thanks, everyone.
Thank you, Professor. Thank you, Dean, for that warm introduction. I'm thrilled to be here. Of course, I'm grateful to the Utah Project, University of Utah, School of Business, School of Law, and all of the organizers of today's convening. Of course, I'm speaking for myself. I'm not speaking for the commission, any of the commissioners, or the staff of the commission. And before I begin, I want to recognize a few people. I want to recognize our paralegal, Bryce Tuttle, who has truly been my intellectual partner in the thinking that went into these remarks. And I want to express my deep gratitude to Max Miller, his colleague, my attorney advisor, as well as our law clerk, Kate Conlow, whose research and support have been absolutely indispensable. At the time of its incorporation in Ohio in 1870, Standard Oil was already the wealthiest company in America with $1 million in assets and 10% of the country's refining capacity. That rose to 25% just 2 years later. Then in 1882, the company's stock was combined with the assets of 36 other companies to form the Standard Oil Trust. By 1890, it controlled 90% of oil refining in this country. The fundamental idea behind John D. Rockefeller and his partner's success was that they could make more money by not competing. And that idea made him rich. John Rockefeller would become the first billionaire this country has ever seen. Copycats followed, and they followed quickly. The American Cottonseed Oil Trust, with 75% of the country's production capacity. The Sugar Trust, with 85% capacity in the eastern U.S. The Whiskey Trust, the Beef Trust, which combined the 4 great meatpacking houses of Chicago. The public caught on, and outrage started to build. First in the state houses in New York and Kansas and Iowa, and then in Congress. By March of 1890, when he stood on the floor of the Senate to argue for the bill we now know as the Sherman Act, John Sherman was clear on who he was targeting and who he wanted to help. He was focused on, in his own words, quote, a new form of combination called trusts that seeks to avoid competition by combining corporations, partnerships, and individuals, often under the control of a single man called a trustee or a chairman or a president. Such a combination can control the market, raise or lower prices, as will best promote its selfish interests. The law of selfishness, uncontrolled by competition, compels it to disregard the interests of the consumer. It dictates terms to the transportation companies. It commands the price of labor without fear of strikes. For in its field, it allows no competitors. Close quote. Hear that last line. Commands the price of labor without fear of strikes. Senator Sherman was driven in part by the need to protect labor. And from the beginning, American antitrust law aimed to protect worker organizing rather than limit it. I've been thinking a lot about those remarks after reading about something that happened about 110 years later in 1999, and then involved my own agency, the Federal Trade Commission, along with a group of truckers who worked the docks across the eastern and western seaboard and the Gulf Coast. The truckers didn't get a salary, didn't get an hourly wage. Most of them were technically, at least, independent contractors who got paid for each trailer they moved from one place to another. $35 for each of those trailers. Over the years, as oil prices went up, the shipping companies raised their rates to account for that. But over all those years, the truckers' $35 stayed the same. After expenses, the truckers often barely made the minimum wage. According to the founder of the Port Truckers Association, a gentleman named Robert Bates, 90% of those truckers could not afford health insurance for their kids or their families. Mr. Bates said, quote, these guys are on the road 50 to 80 hours a week trying to bring home enough money to pay for their house payment and for maintenance for their truck on the weekend. Some days, all they'd see would be 2 to 3 trailers a day. Quote, how do you live on that? Asked Mr. Bates. But here's the thing is that it wasn't like on slow days, the truckers could just do something else. The truckers did not control their own time. The ports they worked for forced them to haul equipment for repairs for free. They forced them to load the containers for free. Every hour the truckers spent on call waiting for another trailer, also free. Yet every time the truckers in one port got organized to ask for an increase on those $35, the shipping companies would just divert their ships one port over. So Mr. Bates called up the truckers in Baltimore and in Charleston and in Galveston and in Jacksonville and Los Angeles and Long Beach and Seattle. And he organized what he described as the first gathering of its kind. a meeting to try to get the port truckers a union contract. Then 10 days before the meeting and 2 days before Thanksgiving, Mr. Bates and his colleagues were issued subpoenas to testify before the Federal Trade Commission. According to press reports, the subpoenas explained that the commission was investigating whether the truckers, quote, are engaging in unfair methods of competitive pricing. Speaking a year later, Mr. Bates explained that he now didn't think they'd be able to get that union contract because, quote, we have to abide by the antitrust laws in America, according to the FTC, because each of us, as they say, is an independent business, because we are independent contractors. Truckers used to earn what was a solid middle-class living in this country, but now those earnings are a shadow of what they used to be. And what happened in trucking is part of a much broader trend where companies demand more and more control over their workers while taking less and less responsibility for them. And they do this typically by hiring or misclassifying them as independent contractors. This trend has disproportionately affected lower paid and more dangerous jobs. Unionizing might give these workers a way out, a way to fight for better wages, better benefits, better working conditions. Unionized truckers, for example, typically earn about 20% more than their non-union counterparts. But as Mr. Bates discovered, when independent contractors organize, they are often accused of breaking our nation's antitrust laws. In other words, because of antitrust, the people most vulnerable to mistreatment are the ones least capable of organizing against it. I think we need to ask ourselves, is this really what Congress intended? We are here to talk about antitrust, a body of law that was born to rein in John D. Rockefeller and the oil trust, the beef trust, the sugar trust. Did Congress really mean for that law to target Robert Bates? Did it really mean to target uninsured truck drivers barely making the minimum wage? Did it really aim to block their union contract? And if not, what do we do about that? That's what I want to talk with you about here today. The need to protect worker organizing has been at the center of congressional antitrust debates, was at the center of them for 40 years. 1890, 1914, 1932. In each of those years, Congress amended the law to make sure it was not used to stop worker organizing. But courts turned each effort on its head. As early as February 1889, during a debate around the bill that was the predecessor to the Sherman Act, Senator James George of Mississippi warned that as written, the bill could be turned against farmers and laborers. Language in that original bill banned any combination that raised prices to consumers. And so Senator George thought that this language on price could be turned against working men organizing for better wages because increased wages may increase the price of goods. But it wasn't just Senator George who issued this warning. The same warning also came from Senator George Vest, Senator Henry Teller, and Senator William Stewart. And each of those senators was specifically concerned that the language on price to consumers would be used to stop worker organizing. And Senator Sherman didn't like this. He shot back that organizing workers, quote, are not affected in the slightest degree, nor can they be included in the words or the intent of the bill, close quote. Nevertheless, in response, the bill was amended not once, but twice. A lot of people know about one of those amendments. They don't know about the other one, Aldrich Amendment. And it was amended 2 times to clarify that it would not apply to combinations of workers trying to reduce hours or increase pay. The bill went to the Judiciary Committee, and there, in the Judiciary Committee, that language around price that had been making everyone concerned, this was the key language again, that Vest, Teller, Stewart, George were all worried about. That language was dropped. And so logically were the labor exemptions intended to protect workers against that language. The law passed the Senate on April 8, 1890, by a vote of 52-1. Who voted for it? Senator George, Senator Vest, Senator Teller, and Senator Stewart. The senators most concerned about the bill's impact on labor voted for the Sherman Act. Unfortunately, the courts basically ignored that legislative history. Instead, they looked at the statute, they didn't see any express exemption for labor, And they proceeded to turn the Sherman Act into a, quote, savage weapon, close quote, against working people trying to organize. The act was used against longshoremen in New Orleans in 1892. Those longshoremen organized black workers, white workers, printers, hearse drivers, musicians, carpenters into a 20,000-person strike. Federal prosecutors indicted those organizers under the Sherman Act. And then a federal judge, Judge Billings, he looked at the legislative history, saw that the law was focused on, quote, the evils of mass capital, close quote, and then he upheld the injunction anyways. The act was used against people working 16 hours a day for the Pullman Palace Car Company in Illinois. In 1894, their wages were cut by 25%. They started to run out of food. They asked to meet with George Pullman, and he fired them instead. So they went on strike. Prosecutors used the Sherman Act against the union organizers, and the Supreme Court voted 9-0 to uphold the contempt of court conviction based on that injunction and sent their lead organizer, Eugene Debs, to prison. And finally, the act was used against 250 hatters in Danbury, Connecticut. Now, you hear hat making, that may seem kind of quaint, maybe harmless. In reality, industrial manufacture of felted fur hats required extensive use of mercury. A study would later find that of 100 union hatters in Danbury, 43 of them had mercury poisoning. The report said, quote, that boys 20 and 21 years old are already so badly poisoned that their hands shake continually, while many of the men who've served longer at the trade cannot even feed themselves, close quote. Instead, people often accuse the hatters of being drunks. In 1892, these men sought to unionize D.E. Lowe and Company, the hat maker in Danbury. Mr. Lowe sued the men along with the national union leaders under Sherman, and the Supreme Court sided with Lowe 9-0. The court focused on the fact that the men had worked with non-employee union leaders to call for boycotts of anyone who did business with Mr. Lowe, not just Mr. Lowe himself. Mr. Lowe won a settlement of $6.8 million in today's money. But he didn't just go after the hatters individually. He seized the hatters' family homes. And those were only saved after union members across the country donated an hour of their wages to support the men. These narrow readings of the Sherman Act infuriated Congress, and that fury crested in passage of the Clayton Act in 1914. One senator said that the Sherman Act had been, quote, tortured into a meaning that transformed the law intended for the relief of the plain people into an instrument for their oppression, close quote. Another member of Congress, Thomas Conup of Wisconsin, he declared, quote, we are aiming at the gigantic trusts and combinations of capital. We are aiming at the dollars and not at men, close quote. Now, Congress had seen in the Danbury Hatters case how courts were drawing these lines between employees and non-employees, and so Congress drafted language to protect labor organizing by both of those groups. Section 6 of the Clayton Act says that, quote, the labor of a human being is not a commodity or article of commerce. Section 20 of the Clayton Act establishes a set of protections for employees and then sets out an additional set of protections for, quote, any person. No antitrust injunctions, quote, shall prohibit any person or persons from stopping to work, from telling other people not to work, from telling others to boycott a business, and the list goes on and on. This time around, the federal courts read the Clayton Act's labor exemptions so narrowly that they basically deleted them from the text of the law. Courts in the 1920s alone enjoined over 2,100 strikes. It was so bad that one scholar actually concluded that the Clayton Act did not stop any injunctions from issuing under the Sherman Act. Now, for me, of those 2,100 cases, the one that stands out the most took place in Mingo County, West Virginia. In the early 1920s, coal miners there tried to unionize what had historically been a non-union coal field. Their wages had been going up, but they hadn't kept pace with inflation, and they certainly hadn't kept up with the 600% earnings increase for the mine's owners, called the Red Jacket Coal Company. One of those union miners, Frank Ingham, would later testify before the Senate about the tricks that the coal company would use to keep their wages low. The men were paid by the carload of coal, right? They weren't paid by the hour or by the day, but by the carload. But they weren't paid in cash. Instead, they were paid in scrip redeemable exclusively at the company store. When the men asked for a 10-cent increase over the normal 66 cents they got on each carload of coal, the company gave them 9 cents. But then the next time the men came up out of the mines, they looked at the company store, and every item at the store had been marked up by 5 to 25 cents. The men called a strike. The company sued under Sherman, and the Fourth Circuit said that the union leaders involved in the dispute, quote, are neither employees, ex-employees, nor seeking employment, and therefore the labor exemption in Clayton did not apply. Yet again, Congress was outraged. Congressman Fiorello LaGuardia denounced the few federal judges who had willfully disobeyed the law. And he went on, quote, they emasculated it. They took out its meaning as intended by Congress. They made the law absolutely destructive of the very intent of Congress. And so Congress passed the Norris-LaGuardia Act of 1932. Now, the opinion I was just talking about, the Red Jacket opinion, that relied on a separate Supreme Court case called duplex printing. And in that case, the court had said that the Clayton Act labor exemption did not protect people who weren't, quote, standing in the proximate relation of employer and employee. Proximate relation, that was a key language. So Congress literally took those exact words and said the opposite. And so the Norris-LaGuardia Act expressly directs that the antitrust exemption for labor disputes applies, quote, regardless of whether the disputants stand in the proximate relation of employer and employee. But they also didn't just do that. Like with the Clayton Act, Congress also made a declaration of policy. They declared it policy that Norris-LaGuardia aimed to restore, quote, actual liberty of contract, close quote, to, quote, the individual unorganized worker. In contrast to what happened after Clayton here, the courts are a little more restrained. After all, the Lochner era was coming to an end. But the narrow readings still followed. In a case called Columbia River Packers, the Supreme Court excluded from the protections of the labor exemption a group of fishermen on the grounds that they were, quote, independent businessmen who were selling commodities and not their labor. That decision would be used to exclude from the exemption a range of other workers classified as independent contractors, some of whom didn't actually sell commodities. And in at least 2 circuit courts, these precedents allowed for antitrust suits against people like the port truckers from 1999 and like Mr. Robert Bates. But let me be clear, I'm not here to criticize a 23-year-old agency decision, nor am I here to criticize FTC staff. As I hope is clear from my remarks today, my critique is of the courts who interpreted the labor exemption so narrowly that its language was repeatedly used to stop worker organizing rather than to protect it. And taking a step back, honestly, I suspect that today, a lot of people like Mr. Bates may be technically classified as contractors, but they are not independent. 50 years ago, so-called owner-operators, these are truck drivers who either own or lease their vehicles, they were much more likely to haul for multiple clients with multiple trucks and multiple employees. Even by the late 90s, the vast majority of those truckers had one client, and they work for that one client with one truck, with one employee themselves. In fact, 90% of them had permanent leases that required them to haul exclusively for one company. And the control exerted through those exclusive leases is reportedly exacting. One trucker said in a recent review, "They can tell you when to breathe," were his words. Now that control matters when we apply the labor exemption. Why? Because the Supreme Court in that case, Columbia River Packers, didn't decline to protect the fishermen who were trying to organize. They didn't just do that because they sold commodities, and they didn't just do that because they were, quote, independent businessmen. If you look at the language, the court's very careful with its words. The court says that it declined to protect those fishermen because they were, quote, independent businessmen free from such control as an employer might exercise. So I want to end on one last case that in my mind offers a different way of looking at these questions. And it actually takes place at a horse track about an hour outside of San Juan, Puerto Rico. Like hat making, horse racing might strike your ear as harmless, as fun. Consider, however, that racehorses can weigh almost up to 1,500 pounds. They can hit sprints of 55 miles an hour. And when they hit the ground, they can hit it with a force of up to 3,000 pounds. The average jockey is sidelined by injuries multiple times a year. Now, if you want to work as a jockey in Puerto Rico, there's just one place to do it on the island, and that's the Camarero racetrack in Canóvanas. And when you race, unless you finish in the top 5, you only get what's called a mount fee. And in Puerto Rico, that's $20. And that is a fifth of what jockeys are paid in the US. And that hasn't changed since 1987. These rates keep most of those jockeys in poverty. And as a result, the Jockeys Association has for years demanded, quote, pay and benefits that do justice to their dangerous profession. In June 2016, those jockeys threatened to strike and demanded higher pay. The horse owners wrote the jockeys a letter, carefully informing them that, quote, they are independent contractors, and as such, they are not a union, and therefore they cannot go on strike, as that would violate antitrust laws, in particular, the Sherman Antitrust Act, close quote. But the jockeys went ahead, and 37 of them went on strike for 3 days. The horse owners and the racetrack sued under the Sherman Act, and the jockeys lost in district court. The judge awarded them treble damages, the owners, treble damages well over $1 million. But like with the Danbury Hatters 100 years earlier, the owners didn't just hold the jockeys liable. They also sued each jockey's spouse or domestic partner, making that $1 million award recoverable against not just the jockeys, but also their families. I said this case ended differently. It did. On appeal before the First Circuit, Judge Sandra Lynch didn't dwell on whether the jockeys were correctly classified as independent contractors. Instead, she and her colleagues pointed to that language in Norris LaGuardia, saying that this didn't matter. She instead focused on what she saw as the core question in Columbia River Packers, whether what's at issue is compensation for labor rather than commodities. She and her colleagues nullified the judgment, dismissed the case, and in my view, followed the letter and the spirit of the labor exemption. The jockeys and their families won. I'll ask it again. Antitrust, a law written to rein in the oil trust, the beef trust, the sugar trust, a law aimed at, quote, the gigantic trusts and combinations of capital, a law aimed at dollars and not at men. Did Congress really mean for that law to target 20-year-old hatters with mercury poisoning? Did it really mean to target coal miners paid in worthless scrip? Did it really mean to target 36 jockeys risking their lives for $20 a ride? Is this really what Congress intended? I think the answer to that question is a very obvious no. And I think Congress answered that question not once, not twice, but 3 times, each time in a louder and a clearer voice. And we're in a law school, and so for those of you itching to cite to me Justice Scalia's famous aversion of legislative history, I see your Scalia and I raise you a Holmes, a then judge, Oliver Wendell Holmes Jr., whom the Supreme Court quoted in 1941 for the very question of how broadly they should read the labor exemptions in Clayton and Norris LaGuardia. This is what then Judge Holmes said, quote, the legislature has the power to decide what the policy of the law should be, and if it has intimated its will, however indirectly, that will should be recognized and obeyed. The major premise of the conclusion expressed in a statute, the change of policy that induces the enactment, may not be set out in terms, but it is not an adequate discharge of duty for courts to say, we see what you're driving at, but you've not said it, and therefore we shall go on as before, close quote. Oliver Wendell Holmes. When it comes to the antitrust and labor exemption, we know that history. We know what Congress was driving at. Congress meant to strengthen labor's hand when it fought the trust, not weaken it. And so we cannot go on as before. Congress has made it clear that worker organizing and collective bargaining are not violations of the antitrust laws. And when I vote, and when I consider investigations and policy matters, that history is going to guide me. Thank you.